Good morning, everyone. I'm Erin Turbot, the Public Information Officer for the Wyoming Department of Workforce Services, and I'm thrilled to welcome you to today's virtual training series, Employment Classification in Wyoming, Getting It Right. This series was created based on your feedback, and we're excited to bring you topics that matter most to you. Be sure to check out our website at dws.wyo.gov/VTS. One of my team is going to drop that link in the chat. And you'll be able to find upcoming sessions, registration, and recordings of past events. Today's session is being recorded, and all materials will be available on our site within a few days. If you have questions about during the presentation, just pop them into chat, and our presenter will answer them as we go. Now let's dive in. Please join me in welcoming today's speaker, Jason Delo, Labor Standards Program Manager for the Department of Workforce Services. Welcome, Jason.
Thank you, and good morning. Yes, as a way of background, we'll kind of go over some of the things that labor does. We enforce fair employment law in the state of Wyoming, as well as wage and hour law, child labor law. We also set and enforce the Wyoming prevailing wage and administer the resident contractor program. And today we are going to be talking about employee classifications. Now, in general, Wyoming's law does not dictate how to classify an employee as full-time, part-time, seasonal, temporary, what have you. It does, however, get into what makes an employee and helps distinguish between someone working as an employee versus someone working as an independent contractor. We often refer to, or these folks often get referred to as 1099 workers, based on the IRS tax form they get at the end of the year for tax purposes. The independent contractors, properly classified, are not employees, and as such do not receive a number of benefits that regular employees would otherwise receive, such as the independent contractors are not eligible for overtime pay. They're not subject to minimum wage. They don't get employment insurance or workers' comp benefits. They're not covered by the FMLA or the Warren Act. And generally they're not subjected to collective bargaining agreements between unions and employers. So obviously there's a lot of benefits to having someone as an independent contractor financially over having them as an employee. And because of this, folks often do what we call misclassification of employees as independent contractors, i.e. they call them independent contractors, but in fact, they don't meet that definition. Now, misclassifying someone in and of itself is not a violation of the law, but doing so can put you at odds with other laws and cause some other problems. If you've misclassified somebody, you may end up having to owe them overtime payments. You may end up having to make up for minimum wage payments. You probably will have to have withheld taxes from them and paid into taxes for the unemployment insurance program and the workers' comp programs. When you misclassify someone, these things can kind of add up. And if it ever gets discovered that they've been misclassified, can end up having to pay a lot of back wages, back taxes, along with penalties and fines. So labor standards usually gets involved in determining somebody's classification when someone comes to us saying they're an employee and files a claim for wages or a fair employment charge of discrimination. Generally, unless there's overwhelming evidence presented at the outset of the case, i.e. The individual bringing the charge themselves says that they're an independent contractor, or they provide substantial documentation that they're an independent contractor, we will investigate the matter as to whether or not they're misclassified. At the same time, we're investigating the underlying wage complaint or fair employment complaint. When we usually get told that folks are independent contractors is usually when an employer, as a defense to a wage claim or a fair employment practices claim, asserts that the employee is an independent contractor, and therefore Wyoming labor standards does not have jurisdiction over the dispute. Um, if there's anything I would like folks to take away from today's presentation, is that simply giving somebody a W-9, having them fill that out so you can provide it 1099 at the end of the year does not make an individual independent contractor in and of itself. A lot more goes into it. So what defines an independent contractor versus an employee? Um, Labor standards, along with other agencies, can use a number of tests to determine if somebody's properly classified. Um, we can use Wyoming statute. We can use something called the ABC test. And in particular, Wyoming Labor Standards uses a Wyoming Supreme Court case, Rhodey versus Diamond B Services, in making the determination. So Wyoming statute 27-3-104B is found in the unemployment insurance statutes in Wyoming. And it basically says that an individual who performs services for wages is employed for the purpose of the act, unless it is shown that the individual is free from control of direction over the details of the performance of the services by contract and by fact, represents his services to the public as a self-employed individual or as an independent contractor, and can substitute another individual to perform his services. If any one of those factors is not true, then the individual is considered an employee and not an independent contractor under that particular statute. You'll also see agencies use the ABC test, which is similar to that prior statute in that tests if the worker is free from the company's control and direction, the worker is outside the usual course of the hiring company's business, and the worker is independently established in their own trade or business. Those are the factors you work for there. As I noted earlier, however, Wyoming Labor Standards uses a case that came down from the Wyoming Supreme Court, Diamond B Services, Inc. versus Rhodey. Basically, Mr. Rhodey came to us quite a while ago and filed a claim for wages. The agency found in his favor that wages were owed, and the employer appealed. At the hearing, among other things, the employer raised the argument that Mr. Rhodey was an independent contractor and labor standards did not have jurisdiction to hear his wage complaint. The hearing officer ultimately held that Mr. Rhodey was in fact an employee and that wages were owed. And as a result, the case was appealed to the district court for review. Once again, the district court did their review and found that Mr. Rhodey was an employee and was owed wages. Diamond B then appealed the case to the Wyoming Supreme Court. And the court held, amongst a number of things, again, that Mr. Rhodey was an employee and owed wages. Specifically in the terms of what we're talking about today, the court noted that the overriding consideration in distinguishing between a master-servant relationship and employer-independent contract relationships is the employer's right to control the means and manner of the work. Went on to explain that when a worker is an independent contractor, the employer is typically interested only in the results of the work and does not direct the details of how that work is performed. Essentially, what they're looking for is the more control an alleged employer exercises over an alleged employee, the more likely it is that person is actually an employee and not an independent contractor. So what are the factors we look at based upon that particular Supreme Court finding? Labor Standards looks to the existence of a contract between the parties. A contract being there or not being there is not it's conclusive in and of itself, but we do look for one. We look at the method of payment. We'll go into a little bit more detail on that later. We look into, is there a right to terminate the relationship without incurring liability on either side? Can they quit each other, or are there penalties that they would have to pay to each other if they were to separate? We look at who furnishes the tools, the equipment, materials. We also look at the scope of the work, the control of the premises where the work is done, and if the worker devotes all their efforts to the position or performs similar work for other folks at other times. When we're talking about the method of payment, independent contractors usually set their own pay scale, and they determine the price of their services and they bill or invoice for those services. In employer-employee relationships, it's usually the employer that kind of has the final say on what the employee gets. Employers typically withhold money for federal taxes from pay. The payment of workers' compensation and employment insurance can suggest an employee-employer relationship, but again, in many cases, those things are not being paid into by the alleged employer because they feel that this person is an independent contractor and they don't want to pay into those services for the alleged employee. We also look at as to whether or not the individual has the ability to participate in any employee-like benefits programs from the employer, like retirement plans or health insurance benefits. When we talk about tools and equipment, we don't just look at does the employee or the employers provide all the tools and equipment. We expect to see in some cases, like the trades, where an employee provides a great deal of their own tools and equipment to do it. So we kind of look more into which priority provides specialized tools or tools that or equipment that requires a fair amount of capitalization in order for the work to actually take place or get done. We also look into who's providing the materials or the consumables for a particular set of work or project. Control of the premises. We look at, who gets to say who gets to be on that particular premises. Does the individual issue own or rent the building or own or rent the property, or is it controlled by another party? Scope of the work. We look at which party gets to determine what gets done, when, how, and when things are done. Who gets to say when the work is complete? We also look at, is the alleged employee doing what the alleged employer does as a business? I.e., are they a painting concern that's hired a painter to do the work? And are they saying this painter is now an independent contractor versus if they were to hire a mechanic to fix their car or fix their work truck? It's important to keep in mind that when we look at all these factors, no one factor is determinative. We look at the totality of the circumstances when we're doing these analyses. And so everything's kind of weighed together. Helpful rule of thumb, I'd like to point out to folks is if you are hiring a true independent contractor, you should look more like their customer than they look like your employee. And I just kind of give this as an example. When I go out to have a problem with a faucet in my house, and I go out to hire a plumber. I call up a plumbing shop. I tell them I think needs to come out. They tell me when they're available. When they come out, they tell me how much it's going to cost, and then they bill me for it. I don't get to tell the plumber how to do his job. I don't get to tell the plumber which tools or equipment he should use or how he should approach a problem. I don't get to tell him which materials he has to have around to complete the work. I don't get to tell him when he has to start, and I don't get to tell him when he's done. I just pay him when the work is complete. So any questions on kind of the rubrics we use? Okay. I'm going to go over a couple case studies here, just kind of drive home the point. We had a case of Jack and Jill. Obviously, names have been changed to protect the parties. Worked as a husband and wife team for 123 Trucking, and claimed for wages when Jill discovered that the company that 123 was actually hauling for was paying a higher rate of per mile and a higher per diem rate than what 123 Trucking was passing on to Jack and Jill. 123 asserted that Jack and Jill were not employees and provided copies of their business name, J&J Trucking, their EIN number or employment identification number, and a W-9 that they both signed. And initially, this was a case where it looked very much like it was going to be a case where they were independent contractors and we would not have jurisdiction. However, when we kind of turned that information over to Jack and Jill, Jill came back with a number of pretty persuasive evidence. She came back with the copies of the ad that 123 placed looking for workers, and that's what they responded to when they got hired on. She provided new hire paperwork. that told them that they were going to work as independent contractors, but stipulated this is what the rate of pay was going to be. There were emails between Jill and the owner of 123 Trucking, in which he was explaining to them that not only that they have to be independent contractors, how to actually go about doing that, how to actually file with the Secretary of State, how to get their EIN number, and then offering to reimburse them for the cost of filing with the Secretary of State. We had text messages between the parties, kind of discussing the schedule and dictating basically when Jack and Jill were going to drive, and even denying Jill the opportunity to take time off when she asked for it. Jill also provided an email that noted she was on a 12-month probationary plan after she got into an accident with the employer's truck. And the explanation for the employer doing that was in order for them to be covered on the employer's insurance, they had to show that there was disciplinary action taken against the employees in order for them to continue to be covered on the employer's vehicles. We also saw a text where the employer directed where Jack and Jill were supposed to refuel. And then ultimately an exchange between Jill and the employer, where Jill was questioning what she was getting paid, and the employer actually just fired her. Again, kind of during the investigation, we learned that Jack and Jill did not even own a truck to do commercial hauling. And they signed off on a number of policies issued by the employer. And while there was an independent contractor in existence with 123 Trucking, Jack and Jill never signed off on it. So in the end, we ended up finding that because of all the totality of those circumstances, that Jack and Jill were in fact employees and not independent contractors. However, they were not owed any wages, as the employer had never promised to pay them more than what he actually promised in that initial employment agreement or employment document. So he hadn't indicated he would ever pay them what was being passed on to him by his client. So why does the determination matter? Even though we didn't find that wages were owed. It matters because when we make those kind of determinations, we have to share that information with our sister agencies in DWS. And so in this case, we informed employment tax that this employer perhaps had been misclassifying employees, and they may want to look into it to see if any unemployment insurance taxes were owed or workers' comp taxes were owed. Wyoming Labor Standards also maintains a memorandum of understanding with the U.S. Department of Labor. And in cases where we found a misclassification, we alert the U.S. DOL to that, as there can be a possibility of underpayment of wages through missed overtime payments or even not even paying them the minimum wage when it's all said and done. Any questions on case one? Okay. Case two, Sally versus Bob's Salon. Again, the names have been changed. Sally filed a claim for wages against Bob's Salon, claiming that he had failed to pay her the agreed upon commission and withheld tips from her that she was supposed to be receiving from customers. So when we got the wage claim, we asked Bob to respond to it. And in turn, he responded that she was actually an independent contractor and was renting a chair from the business, and essentially agreed to forfeit 40% of her billed services to Bob in lieu of paying the rent on the chair. Bob also indicated that he withheld 40% of any tips it received from Sally's customers, again, to help pay for the rent on the chair. During the investigation, Bob explained to us that Sally was not actually a full-fledged barber or stylist. She was, in fact, an apprentice, didn't fully know all the ins and outs of the business or what she needed to be doing, and that he was actually charging her more chair rent than he would normally do because he was having to train her and take on the additional challenge of bringing her up to speed. Bob also explained that because she was an apprentice, he had an obligation to withhold taxes and fees from her pay as a work together. During the investigation, we found out that Sally used Bob's point of sale system. She had her did not have her own technology to charge her clients. We also found out that Bob determined how Sally would perform her work, and if there were any problems arising in her work, Bob was the one responsible for either correcting them or smoothing over the relations with the clients. We also noted that Sally actually never worked alone. If Bob wasn't the one shadowing her on her work, another salon or stylist in the shop would basically oversee everything she did. Now, again, this was a case where Sally provided most of her own tools, as would kind of be expected in these situations. But Bob did supply some communal supplies for everybody to use in the shop. Text messages between Bob and Sally indicated that Bob didn't feel Sally was ready to go full time. He wasn't going to let her come in and work as many hours as she wanted. But he was insisting that she come in on every other Saturday to work to help kind of make sure there was coverage in the salon, something that Sally really was kind of reluctant to do based on her own personal schedule. We found out that Bob had actually asked Sally to obtain her own LLC and get her own EIN number. And there even existed a draft rental agreement between the two. But Sally never did any of these things. She never registered a business. She never got an EIN number. She never signed off on the rental agreement. Despite this fact that, they kind of worked together for 6 months by the time labor standards had gotten involved. So the determination was that ultimately found that Sally was an employee. Again, based upon the totality of the circumstances, the control that Bob had over her and her work and how she did it, and who had control of the premises and what have you. We found that Sally was not doing any additional wages because, again, the wage agreement was for 40% of her billed services, so it meant she got 60% of whatever billed services she did. But Bob had unlawfully withheld tips from her and needed to pay back the tips that he'd been taking because the wage agreement did not allow him to do that. He just kind of decided to do that on his own. So what do you do in the case of misclassification? Now, if you're an employee, we would suggest you contact either us or the U.S. Department of Labor, possibly contacting the IRS, as well as Wyoming's employment tax folks. If you're an employer and you realize, okay, hey, I may have misclassified someone, the first thing you want to do is kind of, again, make up any missing payments you have to them, particularly if there's many missing overtime or if you've been underpaying them and not paying them the minimum wage. You also want to get right with the tax people as quickly as possible. Doing those things can help prevent you having to pay further fines and penalties down the road. Rather than, again, it can get costly in making things right, but it's better to do that sooner rather than later. And you definitely want to contact the Internal Revenue Service if you have been withholding proper payroll taxes. See what they need you to do to make that right. So here are some resources we have, folks. That link is to the Rhodey versus Diamond V Services for V Rhodey. It's also the number to the U.S. Department of Labor's regional office in Salt Lake City, and the those local numbers you can get from the Internal Revenue Service. Does anybody have any questions?
Jason, we've got some questions for you.
Sure.
And if anyone does have some questions, throw them in. We've got some questions that we're going to go through right now. But if anything comes to mind, go ahead and throw them in the chat and we'll get to them. First question, how is classification handled for remote workers who live outside Wyoming but work for Wyoming-based companies?
Okay, so when you get into disputes involving employment law, the state where the work is actually performed has jurisdiction over that dispute. And so depending on where they are at, that's the states that that state would have to look at whether or not they're an independent contractor versus an employee.
Okay, so I am a remote worker. I'm working in Wyoming, but working for a company that lives in Colorado, say, I would
Mhm.
then have to go to Colorado.
No, you would actually
Oh,
come to Wyoming because you're performing the work here in Wyoming.
oh, I understand. Okay,
Um,
awesome.
um,
Okay, very good. I hope I didn't confuse that for everybody just now. Next question. Are there protections against retaliation if a worker questions their classification?
It depends on if there's other violations occurring. If they've come to us with a wage claim saying, hey, I'm owed wages out of this relationship, there are some anti-retaliation provisions in our wage and hour law that would protect them. Similarly, if they're saying like, they get paid overtime and they've gone to the US DOL, there are anti-retaliation protections there. Simply complaining, hey, you've got me down as the wrong kind of employee, um, in and of itself is not really protected. Um,
Okay. Are there safe harbor provisions for employers who classify workers incorrectly but in good faith?
There are, and that's what I was talking about earlier. If you realize you've got someone misclassified, you kind of want to circle back again, make sure you're paying at least minimum wage, paying any overtime that's owed, and you've paid all the back taxes and straighten things out with the IRS and any other tax authorities. Um, Moving forward, you want to make that relationship on the level again. Um, as soon as you realize that you may have made misclassification. In that case, a lot of the times the agencies won't penalize you further, um, if they get involved.
Oh, great. Okay. And Trisha just put a link to misclassification in the chat if anyone's interested in reading more about that. We have a question from our audience here. Is there a time limit for reporting the issue?
Okay. So again, if you're coming to us trying to file a claim for wages, based on, and you think you were misclassified during employment, you have to do that within 2 years of the issue arising. We can only go back 2 years and looking at those relationships. Um, Now, the US DOL can go back 3 years if they feel the misclassification, the failure to pay, was deliberate. Um, but yeah, that's how that kind of sets the time limits for them to come to us.
Okay. All right. Thank you. Um, if an employee inadvertently did not select to have federal taxes taken out, does the employer's HR have any responsibility?
So if the employee elected not to have taxes taken out,
Yeah.
okay, I believe that would be an issue, for the IRS. And if they filled out their W-2 correctly and said, hey, then that's probably going to be on them. Again,
Okay.
you might want to talk with a tax professional on that one. We don't deal a lot with taxes.
Okay.
Legislation.
Another one from our audience. Is it a good idea if you have any questions about someone's status to talk to labor standards before someone starts working?
Absolutely. I mean, we can field questions about hypothetical situations or situations you're thinking about. Um, Anytime, give us a call. We'd much rather deal with it up front and maybe avoid any problems down the road than have to get involved in something later on and have to do a full-blown investigation to suss everything out.
Okay. Kimberly, I wonder if you would clarify your question. It says employees being fired for doing the job exactly as being trained for. If you could clarify that for us, we will come back to that. Um, the next question we have is many people come in with tribal business issues. Who is the appropriate contact?
Okay, so if you're dealing with a tribal entity, you want to talk to the Tribal Employment Rights Organization, or TARO, and they'll be on the reservation, um, proper. We just don't have jurisdiction over a travel agency, so
Okay. How long does an average investigation take?
it depends. If it's a wage claim, we like to get those done within at least 100 days. We're pretty successful with that. If it's a fair employment case, those can take well over a year. It just kind of depends on the case.
Okay. Another from our audience. If I am an independent contractor, how can I deduct federal taxes, Social Security, and Medicare? Because I'm obligated to do that.
Okay. Again, that's where you probably want to get hold of a good tax attorney or a certified public accountant to help you set those up. Because again, we don't deal with those payroll taxes at labor. We just know that they exist and they have to be paid.
Okay. How does project-based work or seasonal employment affect classification?
Right? So again, it's going to depend on each individual situation. Simply because somebody's working seasonally does not necessarily mean they're an independent contractor. They could just be a seasonal employee. And so when we would look at the factors we talked about earlier. If this person is, meeting these criteria, they would be an employee. It doesn't really matter that you don't intend to employ them for, more than the summer or more than a couple months during your busy season. You would still be entitled to proper classification, and you'd have to get everything right with the tax agencies in doing so. Um, Now, because they can be short term, that could be an indicator that they are an independent contractor. That could be one of the things we look at. But simply because somebody just only works on a seasonal basis does not mean that they're an independent contractor.
Wonderful. Okay, thank you. And in the chat, Karen has added the information for the Wind River, Taro, Eastern Shoshone, and Northern Arapaho Tribal Rights Employment Office, phone number, fax number, and email. Thank you, Karen, for doing that. We have another question. Are there particular industries in Wyoming where misclassification issues are more common?
Um, I mean, right now, misclassification across the board is kind of considered a big problem amongst all state DOLs. I can just tell you that. Uh, it's, I guess, more common when we get into things like truck driving, um, some service industries like beauty shops, where they can legitimately be independent contractors in those industries. Um, and people just kind of get, I guess, a little bit in the habit, or they don't really go through all the rigors of truly making sure that they're an independent contractors. They still want to maintain a great deal of control over those individuals. And so that's where we see these kind of things crop up. But we see it in construction, we see it in across the board, where somebody just decides, hey, I don't want to deal with the hassle of having to set up an account with the IRS or workers' comp, and I just want to get this person paid and done at the end of the day. And so I'm going to call them an independent contractor. I'm not going to withhold taxes, and that's the end of it. Um, but they treat them as an employee in every other fashion.
Okay. So can a worker's classification change over time? And if so, what would trigger that change under Wyoming law?
Okay, it can. It just depends again how much control that alleged employer is exercising over the alleged employee. There was always a potentiality for an employee who's working for an employer to say, "Hey, I'm pretty good doing this thing. I'm gonna go out and hang up my own shingle, and I'm gonna hire myself out to other folks, including you, to do this kind of work." Um, that can happen. Or somebody can just start off coming to you as an independent contractor for a specific project or specific issue. And over the course of time, that relationship evolves and they end up kind of being more of an employee and not so much working for themselves. Um, you got to pay attention to those factors that we talked about. And again, how much control is the alleged employer exerting over that alleged employee? And the more control that they exert, the more likely it is they're an employee.
Okay. So again, what we talked about just a little bit ago, it's if you have any questions, it's always a good idea to contact Jason and his team and ask questions. if you are unsure at all. Looks like I have one more question. And if anybody has others, go ahead and throw them in chat. How does Wyoming classify interns or apprentices, especially if they are unpaid or being paid a stipend?
Okay. Um, Classifying someone as an intern is actually kind of a separate deal. There are other factors we look at. Additionally, if it's primarily if the relationship is for their own education and not for anything else. Um, Again, the more it seems like they're actually doing work for the employer and it's not for their educational benefit, the more likely it is they're an employee. Um, apprentices are almost, or at least usually, um, considered employees. They may be in training, they may be not full-fledged employees in the IC employer, uh, but usually those apprenticeship programs require them to be employees and be have the same benefits as a regular employee.
Okay. I do think that is all of our questions. We had a lot for you. Thank you very, very much, Jason.
Okay.
This is a really informative presentation, and I'm glad we were able to do this, especially now as we're going into the seasonal kind of employment
Yeah.
season, for lack of a better term there. Um, Before we move on, everybody, I would really like to ask you to take a survey on today's presentation. Jason, thank you for advancing that slide. Trisha just put that survey link in the chat, and your input really helps us make these sessions even better. It lets us know what you want to hear, what you want to talk about, what you want to think about. So we really appreciate it if you would go ahead and do that. In the next few days, we're going to email you all the recording of this presentation, the slides, and of course the links that Trisha threw in the chat. Um, while you're completing the survey, Trisha is going to post another link, which is going to allow you to register for our next presentation. Finding support for mental health, for substance abuse, or suicide concerns can feel confusing, especially when you're trying to understand where to turn, what services are available, and how to help yourself or somebody you care about. So we hope you'll join us for You Are Not Alone, Navigating Mental Health, Substance Use, and Suicide Concerns for Yourself and Others. This is a free session focused on helping participants discover the tools, services, and community resources available when support is needed most. Thank you all so much for joining us today. We will see you in December. Jason, thank you again. Thank you so much.
Thank you.
Have a great day, everybody.